is Charles Raab from the University of Edinburgh, as you can see on the board. This is the panel that Ivan Szekely, who will be the moderator, and I have put together, and we welcome you to this panel. We focus on data protection authorities, DPAs, and for several years at CPDP, the two of us have presented panels that highlighted different aspects of the role and the work of DPAs. And so over the years, we've put the spotlight on their role in regulation, their independence, their understanding of information technology, their cooperation with other DPAs, and so on. And the panel that we had a while ago concerned information technology, and Ivan and I actually did a survey, and we published an article last December reporting on the survey of DPAs that we did concerning their familiarity with information technology and how they use it and where they go to get advice on information technology. That article is published, and if anyone is interested in reading it, just let us know and we can send you a copy. Now this year we are focusing on DPAs and their relationships with NGOs, or privacy campaign and activist organizations, groups that campaign, they exert pressure on policy processes or on corporate practices in the interest of privacy protection and also fundamental human rights. And we think that this relationship between DPAs and NGOs has grown in importance, but sometimes it varies between being harmonious and mutually supportive, but sometimes DPAs and NGOs have not quite hit it off very well, and they're mutually hostile and perhaps distrustful of each other. Now, some people have been calling for better interaction and coordination between DPAs and NGOs, but there may be limits to how far that kind of cooperation can go if each of them is seen to be effective in the work that they properly do and independent in the work that they do. Those of you who attended the privacy camp on Monday, which was it Monday? Tuesday, which is an extremely interesting day. The relationship between NGOs and DPAs was actually highlighted in one of the sessions. In fact, two of our speakers here today were part of that. And Giovanni Buttarelli, who's as you know, the European Data Protection Supervisor, in his closing remarks to that session, he said that with the GDPR, it was time for NGOs to be more visible, more specific, and more coordinated. And he mentioned that Article 80 of the GDPR gives NGOs the opportunity to bring complaints and to initiate legal proceedings on behalf of individuals and maybe on behalf of groups. If you look at recital 142 of the regulation, that also explains this. So if there is that new relationship, will it bring NGOs into conflict with DPAs, or will there be an opportunity for more constructive collaboration? So today we want to explore this range of attitudes and conduct between DPAs and NGOs, even though we can only scratch the surface in the very short time we have this morning. But we've gathered together 4 speakers. You can see their names on the board, and I'll introduce each in turn, who are very well equipped to share their observations on these relationships from different standpoints. 2 of them are NGO persons, 2 of them are commissioners or former commissioners. In the traditions of these DPA panels, we will have short introductory statements by the panelists that address several questions that we've asked them to look at. And then we will have further questions to be put to them by Ivan as the moderator before we ask for questions from the audience and answers from the panelists. And Ivan will also, from time to time, ask you, the audience, to do a quick vote on certain questions. Now, the conference program will tell you who is speaking here today and a little bit more about them. So my introductions of them will be very brief. I'll introduce them in turn. But first, before we turn to the speakers, Ivan would like to do a little quick audience vote.
Yes, thank you, Charles. we want to demonstrate right at the beginning of the session, of this panel discussion, that we really want to make the discussion interactive and involve you, the audience. So if it works, I hope it works, you can see the first Blitz voting question. Please don't forget that we use the acronym DPA for any kind of data protection supervisory organizations or institutions, ombudspersons, parliamentary commissioners, government agencies, authorities, any kind of DPAs. In turn, we don't regard any non-governmental organizations as NGOs. We concentrate on civil society NGOs, and especially those who are in some relationship with informational rights or human rights or fundamental rights in general. So the question is, if you take all those things into consideration, in your opinion, are DPAs and NGOs in practice rather opponents or rather allies? So who votes for option 1, rather opponents? Please raise your hands. Nobody. You are very polite and very cautious. Who votes for option 2? Rather allies. Okay, we can get back to this later during the discussion, but that was your first opinion. Before we go on, can we ask how many of you are from the civil society? Would you raise your hands? About half. Okay. Anybody from the data protection agencies or? Okay, that's also an important sector. So Charles, please.
I think that what that reveals is that all the opponents have stayed away. All the people who think they're opponents have stayed away. So it's a biased sample, but there it is. I want to turn now to our first speaker, who is Fanny Hidvegi, who is in the red sweater. She is the European Policy Manager of Access Now, an NGO that defends and extends the digital rights of users at risk around the world. And she used to work at EPIC, the Electronic Privacy Information Center, and she focused on EU and US data transfers. She has a law degree from the Eötvös-Loránd University in Budapest, and she also led the Freedom of Information and Data Protection Program at the Hungarian Civil Liberties Union. Fanny.
Thank you very much. So first of all, I need to apologize because I sound like this. I wish it was due to a lot of whiskey, but I think I just got a cold. So in these short introductory remarks, because I think we will try to keep it as conversational as possible, I will share two very different experiences. One, to work for a grassroots human rights watchdog NGO in a member state, and then as a comparison, working for an NGO here in Brussels. And finally, I will try to find a link that connects those two together. Based on that vote, I would assume that most of you come from more democratic countries than I do, but I'm not gonna do another poll. So I joined the Hungarian Civil Liberties Union in 2012, which was very interesting time in terms of data protection enforcement, because the then new Hungarian government adopted a new law on data protection and freedom of information, and they prematurely terminated the position of the ombudsman, and they set up a new authority. And according to civil society, the new person, the head of that agency, was too close to the government, and the independence of the authority was very questionable. In fact, later on, the Court of Justice of the European Union found Hungary in breach of EU law for doing that, and the sad irony is that the ombudsman got compensated financially for those years of the termination, but Hungarian citizens never got compensated for the years when their fundamental rights were not enforced as they should have been. So in Hungary, I think it's fair to say that the relationship is hostile. I don't know any coordination or cooperation between the authority and civil society organizations that has gone anywhere. That doesn't mean that there are not really great staff members, and I know personal relationships and that kind of cooperation, but on the institutional level, there's nothing. On the other hand, here in Brussels, Access Now is in a completely different position. We are a global civil society organization. We don't do national level enforcement. So our job here is to work with the EDPS, the European Data Protection Supervisor, and also the Article 29 Working Party. And in a European EU environment, when we have the Council, where I've never seen anything that went well for fundamental rights, we have the Commission, which is overly politicized, and against their professional oath, they actually enforce a lot of member state interest in all our digital files, unfortunately. Definitely, these parties are the most important allies. And we look for any opportunity with the data protection authorities here. What links the two is what Charles already described about the GDPR and future opportunities and challenges is, and I'm sure we're going to go into more details about the inadequate solution in the GDPR to leave it as an option for member states to come up with class action and or collective redress. Let's use, that's a better term, collective redress mechanisms. And NGO representation, there's a bigger problem. The EU has been completely incompetent and numb against violations against NGOs as a general matter. There's a shrinking civic space all around Europe. NGOs are threatened by police raids, administrative fines, investigations, smear campaigns, special taxes on funding, banning funding, and I'm yes, the GDPR enforcement is great, but only if those NGOs will exist to enforce those fundamental rights in front of court. So I would like to stop here and then go into details later on. Thank you.
Thank you very much for that. Not a very happy picture, but we can go in to explore that. Yeah. Ivan would like to now conduct the second
Another quick quote, yes, but I would like to offer the opportunity to all the speakers to react on each other's statements. Just to remind you, Fanny said that the relationship is really hostile between in a certain country, in our home country, between the data protection authority and the civil sector in general, NGOs. And also, she criticized the EU bodies for certain reasons. So if you have different opinions, you will have a chance to intervene. And this is exactly why we invited the civil sector representative, because we wanted to give them the voice. Now, okay, that's the voting question. It's related partly to the new GDPR provision, but now, in your opinion, do these civil organizations deserve a special treatment at DPAs? Option 1, yes, because they represent cases concerning many people, class actions, and anything. No, because everybody should have equal rights to turn to DPAs. No positive discrimination for NGO representative. Option 3, yes, but only in cases directly concerning the NGOs themselves. So who votes for option 1? Please raise your hands. 2, 4, 5.5, okay. Who votes for option 2? No. Yes? Almost the same amount. And who votes for option 3? Only in cases 1. Okay, and some of you must have abstained. Okay, then let's go to the next speaker. Charles will introduce you briefly.
Thank you. The next speaker, as you can see on the board, is Peter Schaar, who sits 2 places to my left. And I won't read out all of the things that he has done, but You will, of course, know him as the former Federal Commissioner of Data Protection and Freedom of Information in Germany. He's now the chairman of the European Academy for Freedom of Information and Data Protection. So he told me now he's wearing his NGO hat, whereas before he was wearing his commissioner's hat. But I think he's going to talk from the standpoint of the DPA.
Well, I think I know both sides. So before I became chairman of this European Academy situated in Berlin, I worked with DPAs for more than 26 years. I had been the Deputy Data Protection Commissioner of the Hamburg DPA before I became Federal Commissioner. The European Academy for Freedom of Information Data Protection is an NGO. So to be frank, we get no funding by the government. There are no specific laws defining our tasks or competences. We are completely free to do our work, and our understanding is to use our freedom or liberty to decide to provide a platform for discussions, especially between data protection authorities and civil society, governments and companies and other stakeholders in the field of data protection and freedom of information. So I could imagine that this is one form of sharing the work in our field. When I had been Data Protection Commissioner, my attitude was to discuss at least the issues not only with other commissioners, not only with governments or companies, but also with civil society. So we tried to get them informed and to get information from them, what are their activities, what are their views, but there were not and there are not so many organized platforms for exchange. Of course, data protection authorities as well as groups of authorities like the Article 29 Working Party provide opportunities for feedback. The consultation procedures are the most eminent example, and I've learned that the Article 29 Working Party recently established a working format called Fab Labs, which gives stakeholders the chance to introduce their views on several issues like e-privacy directive, implementation of the GDPR and so on. And I think this is a good step that the data protection authorities seek advice from the society, not only civil society is constituted by organizations of privacy activists, but also for other stakeholders. We need, the data protection authorities need oxygen for their work, and society activists from the different sides might help data protection authorities to come closer to the daily life and the problems. But nevertheless, data protection authorities, to be frank, they have their specific tasks enshrined in legal acts. So they have, the first and most eminent task is that they have to supervise. And in their supervision capacity, they must be neutral. So they cannot come too close to civil society organizations. And if they get or they keep their own information to the society, they might discuss that also with those stakeholders. But at first, these are the interpretations by the official bodies or the institutions that are competent for this field. Sometimes data protection authorities have been named as regulators. So we as German DPAs were not so happy about that. But in general, under the GDPR, this role as regulators will be stronger than it is today all over Europe. And therefore, especially if they understand themselves as regulators, they have to seek for the advice and for the input of the society, not only from privacy activists. Well, we need also the views from civil society organizations outside the European Union. When I was Article 29 Working Party chairman and later on as Federal Commissioner, I also met civil society organizations in the US like EPIC. A relatively new development are the litigation organizations. There are some new NGOs focused on privacy litigation in the private or in the public sector. I think this is a relatively new development in Europe. EPIC does this work since decades, since they started. But I think it is very important, like the Schrems case demonstrates, it is really essential that there are persons and groups that have the power to go to the, not only to the DPAs, but also to the courts to enforce their rights. The Schrems case, the decision in the Schrems case, the first decision of the European Court of Justice, makes it completely clear what will be the effects of such activities. But without these, it was not a class action, to be frank, but these kind of actions, class actions as well as individual actions, but supported by civil society, brings privacy ahead. And without these activities, it would be more difficult to get such decisions. So I stop here.
Okay. Thank you very much, Peter. There are lots of things that you said, which I'm sure we will want to take up later in further questions from the floor and also from the panel. But again, we have a vote to be taken.
A vote?
Yvonne.
Is it working now? Yes, thank you. So again, we would like to learn your opinion on this question. Should privacy advocacy NGOs be critical towards DPAs? Now, we already heard some criticisms. But option one is yes, because DPAs need civil control. It's evident. No, because they both fight for the same cause. That could also be an argument. And option three, yes, but only behind closed doors. I already heard such arguments like this. Let's don't put the arguments in public. So who votes for option one? Yes, because civil control is necessary. Thank you. It's a majority. Who votes for option two? No, because they must fight from the same cause, for the same aims. Nobody. And option three, yes, but let's keep it behind closed doors. Again, nobody. And a few of you didn't want to. Maybe you think the question is already wrong. It's, we know that these blitz voting questions are oversimplified, but there are situations in life when you must answer in an oversimplified manner, so these blitz voting questions are exactly like that. But now let's go on to the next speaker, again from the civil society.
I think that maybe it's a different electorate from the first vote because people have been coming in. And also, if I remember, the vote on the first one was that they are more opponents than, they should be more opponents than, they should be more allies than opponents. Wasn't that the first vote? But now in this third vote, possibly it's reversed itself, that there's more antagonism showing up. Be that as it may, it's my pleasure now to introduce our third speaker, who comes from the world of NGOs, and this is Szymielewicz. Got it right? Very good. Kasia is a lawyer. She specializes in human rights and technology, and she worked for the law firm Clifford Chance on data protection things, and then she was a member of the Civic Advisory Board for the Ministry of Digital Affairs in Poland. She's the co-founder and president of the Panoptykon Foundation, which is a Polish NGO defending human rights in the context of contemporary surveillance, and vice president of IDRI. So, over to you, Kasia.
Thank you. I'm particularly glad that I get to speak after this vote we had. I was joking here to Peter Schaar that if we discuss it over coffee, I probably, I guess most of us would go for the option number 3, because we feel that it can be slightly problematic if in public discussion NGOs, privacy advocates attack too fiercely DPAs if really it is the case that they fight for the same. I do believe in Poland, because that's the perspective I was asked to bring to the panel, that at least in my country we still fight for the same case, for the same cause, which is strong privacy protection. And in that sense, fundamentally, I do see NGOs in Poland like Panoptykon Foundation and DPAs as allies that should work together. But that's the principle. So in principle, as Panoptykon, we would always say that it's in our best interest to have strong DPA with a decent budget to operate, with strong political independence, safeguards for independence, and with effective redress procedures. And I suppose the DPA wants exactly the same. But then what happens if in practice this is not the reality we live in, yes? What happens if in practice, and that's actually the Polish case right now, DPA it's not fully independent in political terms. Under the proposed legislation right now, that independence will be even more limited. We will have strong influence of Prime Minister in the process of electing the main DPA, and the deputy DPAs supposedly will be appointed by other ministries. So there will be actually zero independence when it comes to deputy DPAs. What happens if that institution has not enough people, not enough staff, not enough money to operate properly, and it causes delays? Or what happens if it's not managed properly? That can also be the case. Not every DPA can be excellent manager. It happens, and then people wait 1 year, 2 years, 3 years to get their cases resolved. What is our role then as independent privacy advocate? What should be our support or our policy on this? So that's a difficult position in which we find ourselves right now in our country, somewhere between the rock and the hard place, because the last thing we want to do is to expose in public that we might have weak or not fully independent DPA, because we really need this body, and we would like to see it strong, independent, and active. But the pragmatic or the political reality happens to be different. I can give you an example of what happened when the current DPA in Poland proposed its own procedure while implementing the GDPR. So a couple of months ago, we were commenting in public consultations on the proposition made by the DPA himself on how GDPR should be implemented. And there were quite a few points where we simply disagreed in the best interest of privacy and data protection. So in response to the current situation with huge delays in procedure, the DPA suggested that the deadlines should be extended. We should simply allow in the law at least 6 months for the DPA to hear individual case, if not 1 year in more complicated cases. They also suggested 3 months for moving the case from the DPA to the court, under Article 79, when citizens or any other plaintiff disagrees with the decision and wants the court to revisit the case, the DPA wanted 3 months just to bring papers from its own office to the court. Obviously, we disagreed with this procedure. We thought, no, this is not the right way to go. If we have problems with delays, we have to find another solution rather than writing this in the law. When it comes to our role, our formal position as NGOs in the procedure, Polish DPA was never a strong fighter for increasing our formal position. So what we have now in Poland and what is likely to remain under GDPR is only our right to represent individual, more or less the same as you have in any standard procedure. So Article 80.1 of GDPR is somehow implemented. We will have the right, but nothing more than that. We will not have special collective redress procedure, and not at all in the courts. In the DPA, we will be able, and we are able, to suggest the case and join the case as third party to represent the societal interests, but we are not able to operate, to act as plaintiff, to actually start the case ourselves and fight for it in the societal interest. The reason why DPA and government both are not suggesting this, I'm questioning those reasons, because what we hear is that there is a risk of abuse. There will be very many fake NGOs or non-ethical NGOs abusing this procedure. My response usually is that that's exactly why we have independent DPA, to say, no, we are not taking this case because you are not representing societal interests. You are representing your own interests, and you are actually fighting for example, compensation for yourself as NGO. But still, I mean, those arguments are not heard, and I'm afraid this is mostly because DPAs are afraid, DPA in Poland might be afraid of too many cases, or too difficult cases to be brought by NGOs. So my feeling right now is that while we certainly operate in the same value system, and we certainly fight for similar causes, we use different measures. And it's very comfortable for the DPA to position us as this soft power, helping in public communication, helping in raising awareness of citizens. So we always get invited to conferences, we always get invited to speak and support, and nobody will ever question our work on these grounds, but we are not treated as real partner when it comes to enforcing the laws. And that's simply that's something I would like to see changing under GDPR. And finally, I think our role as watchdog in the process of electing DPA is welcomed by everybody. So we always do those monitoring procedures as Panoptykon together with other NGOs. We always watch closely the process of electing the new DPA. But if the result is political, there is really nothing we can do about it, and we will have to play with the body we get from the government. Thank you.
Can I have a short question to you? Do you also remember some positive examples where you were able to work together with maybe not the present regime, but before, just to make the picture wider? You are very critical, and that's okay. But
no, if you got that point as very critical, then I didn't transfer it properly. As I said, I mean, in principle, we work together. But we are not able to do this work as partners. We are not invited to, for example, intervene in cases. Well, so far we didn't even try, because the law was so weak and was not really enforceable to the extent we wanted. So I think that's the main reason why why none of the NGOs I know, including us, we never tried to join the proceedings in front of Polish DPA so far. As I said, we do cooperate as soft power, if I can use that term. So in public communication, in raising awareness, in talking to the media about the value of data protection or the value of independent UN DPA, yes, of course, here we cooperate, but it's not cooperating, it's working alongside, really cooperating. I don't think there were procedures for this, and I don't think there was political will to do that.
Okay. Before we give the floor to Willem, the three of us have some very brief things to say. Yes, Charles, and then Fanny would like to say something.
On what we've heard from Kasia in talking about not having, probably in Poland, not having the right to bring litigation collectively. You can join cases, but not bring. I think this is one area where the margin of appreciation, so-called, for national variation in the implementation might be very crucial and might be very telling. And it could well be that over subsequent years we begin to see not the bringing together of harmonization and uniformity across Europe, but a further divergence amongst member states. And then maybe in 20 years' time there'll need to be another regulation to bring it back together again. So you get this concertina out and in over the years in terms of the way particular things of great importance might be implemented differently in different states. But before we move on to our last speaker,
Fanny would like to make a very brief
Yeah, it's a question
intervention,
actually.
yes.
So Kasia made a point about budget, which I would like to echo, because what we hear from many data protection authorities is that with the GDPR, there is an insane increase in workload on these authorities, and they don't necessarily get the appropriate resources to meet that. And as a result, what is unfortunate from a user's perspective is that yes, the GDPR is coming and all the companies are complaining that they're not ready, which is another question why they are not ready since 20 years. But people have not heard about the GDPR and their rights and how to enforce them. And data protection authorities have no capacities to run effective campaigns. So I was wondering if you can respond in your remarks, how is the situation in Belgium in that regard?
Okay, so I'm afraid we still have a quick voting question. That's for the future. How this controversial or complex relationship between the two kinds of organizations be improved. Option 1, DPAs should become more open to civil society inputs. Option 2, NGOs should not criticize DPAs for not acting like campaigning organizations. That's the other side of the coin. Option 3, both should keep their own style but engage in discussion and joint activities more often. So who votes for option 1? DPAs should be more open. Yes, a minority. Who votes for option 2? NGOs should not criticize. Okay. Option 3, both should keep their style and work together. Then the majority of that's an optimistic voting result. But now we turn to our next speaker, and Charles will introduce him.
And our fourth speaker now is Willem Debeuckelaere, who is, as you know, the Belgian Data Protection Commissioner. He's been president of this commission since April 2007, but also before. He was president of the Human Rights League from 1982 to 89, so I suppose that was a kind of NGO.
Yes.
And then he was head of the cabinet of the Belgian Minister of the Interior and counselor to the Ghent Court of Appeal. So he comes from a legal background in that sense. So without further introduction, Willem.
Thank you, Charles. Yes, you mentioned it. I was in the 80s. I was president of the Human Rights League, so it was an NGO, and that was also my first time that I was confronted with discussions on privacy. I say privacy because data protection was on that moment still coming, but it was not really regarded as a right, a fundamental right, as it is nowadays. And to be frankly, if we have to give an answer, if we are opponents or allies, I think we are mostly allies, and sometimes we are opponents. I will give some. I think I have 3 points to highlight, and one of them is I think it's very important, and also the last question. I think I'm very happy that everybody is in favor of, practically everybody was in favor of the third option, and that is also what I have seen in the last decades, and yet you can see also appearing into the reality of the legal machine, the making of the law. I think on digital rights, for example, very important case. I think at the actions of Max Schrems, who are already said, but we have had here in Belgium quite another situation. We have had a lot of discussions between the NGOs and the Data Protection Authority according to data retention. Data retention was a very hard matter for us. We were allies in combating the directive, because the directive of 2006 was really a monster. But if you look into national legislation to data retention, you can fine-tune, you can try to find a balance between the two fundamental rights who are at stake. At one hand, data protection, privacy. On the other hand, you have the right to be free, and free is also that you have the right on security. And that was, for us as a Belgium Data Protection Authority, a big issue, because in the first time we got projects of legislation that we have not accepted as Data Protection Authority, but we have had a lot of discussions with several academics, but mostly with politicians, and at the end we came to let's say an agreement on how this legislation on data retention should be regarded. But the Belgian Data Protection Authority, the League of Human Rights, where I was 2 decades before president of it, they were not agree with it. They go to the Constitutional Court and they won. So on that moment you are not really an ally, but you are more an opponent. But you have to always to be honest. If you are losing a case, maybe there are reasons for it, and we have accepted it. We have a lot of, and that's my second point, we have a lot of interference with NGOs, all sorts of NGOs, the classical ones, so to say. We have a good relationship with trade unions. It was not mentioned, but trade unions are also a sort of NGOs. We have also a lot of the we have had cooperation with associations of patient rights, also with women equal rights movement. Don't forget that in Belgium the right of privacy have been introduced, so to say, as an atomic bomb in our constitutional and legal system, when the Court of Human Rights from Strasbourg in 1979 has condemned Belgium because they were not respecting equal rights of women, and from their affiliation. It was Article 8 that was at stake. It was the case of Marx, Paula and Clara Marx, who was one of the leading cases, maybe now forgotten, but in the first decades of the Court of Human Rights, it was there, and it was a Belgian case. And so privacy and Article 8 of the European Court, the European Convention, was really on that moment very prominent in the discussions, in the legal discussions, and also in the making of legislation. We have had also some cooperation in handling complaints. We have the experience that an NGO who can really working very good, because they have sometimes lawyers, they have sometimes also experience, they have the capacity to help people to introduce a complaint, to make a file, a whole dossier. So we have the experience that in some, mostly, that if an NGO is helping an individual or a group of people, that it is leading to a much more bigger, better success also in handling complaints on the field of not only the Data Protection Authority, but afterwards also to when you are going to the court. I think that for me it's quite a necessity that to have strong and very aligned NGOs, and these NGOs have to be very critical also for the Data Protection Authority. As I mentioned already, the case of the data retention is exemplary for that, and I think that they have to be very critical. I know by experience that it's sometimes it hurts when you are in the Data Protection Authority, but if you have this function, you have to be able to catch and to work with these critics. My last and third point is Article 8 of the General Data Protection Regulation. I don't have much time anymore, but if you're looking to Article 80, there the General Data Protection Regulation is giving the obligation to every member state to introduce the possibility to help organizations, NGOs, are mentioned in Article 80.1, to go to court to defend their rights. Article 80.2 is maybe much more important, because this article is giving the possibility, not the obligation, but the possibility to the member state to create the possibility for NGOs and other organizations to go in place of other people, but to go to court to defend data protection and privacy rights before the court, before the Data Protection Authority, without really representing an individual. And we have the experience in Belgium that it is very important that it can be done. I will give you the example of the Facebook case, where we know maybe today, maybe next week, we will receive the judgment of the Tribunal of First Instance here from Brussels in the case of the Belgian Data Protection Authority against Facebook. We are working together with Germany, with the Dutch DPO, with the French and the Spanish on that, and that is all part of the game against that. But it is very important that also NGOs and foundations and other organizations should have the possibility, should have the power to go to court and to defend the rights of the citizen, because data subject, I find it always an awful word. So I can conclude with it, and I think these 3 points are important to me as Belgian Data Protection Authority.
Thank you very much. Can I be heard? Yes. The landscape is very complex. Your words were rather optimistic, but I would like to pose a somewhat provocative question to the whole panel. First, maybe to the two NGO representatives, and then to the two DPA representatives. In 2004, there was a case in Hungary when civil society awarded the Big Brother Award. Perhaps you know what it is. It's a negative award given to those who did the most to destroy people's privacy in the preceding year, was given to the Data Protection Commissioner. It was awarded. And moreover, the commissioner attended the ceremony. He took over the prize or the award, and made a short speech in which he told the audience why he disagrees with all this, but he was there. Okay, so the question to the NGO representatives: do you regard such actions as part of the toolbox in your relationship, or you would think it's not permissible for certain reasons? So what's your opinion on this? And then I will ask the same from the other side.
Well, I mean, it's very difficult for me to put myself in the shoes of Hungarian organizations. If I had in my country, as I understand that the situation in Hungary, not functioning, not independent DPA, which is in a way a waste of institution, and that brings nothing positive to the protection of privacy, we might consider drawing attention to this. But honestly, if this is a structural, systemic problem, if it's not just the wrong behavior or bad intention of a particular person, but it's a structural problem of how this institution is designed, for example, then I would probably not try to draw attention to this particular person. Yes, I see a value in differentiating how we approach the structure of the institution from how we judge the work of a particular person. So my opinion is that we should work very hard as NGOs in establishing the best possible procedures for DPAs, the best possible safeguards for them. If we fail, be very loud about it. And yes, if we get good procedures, but the wrong person in the seat, wasting them in a way, then I would probably consider something like that, but only in the case where I could attribute the blame not to politics and to the laws, but to a particular person.
It was about, in that case, it was about a concrete decision of this person, and that's why they were, it was the audience award, so to say, so it's not awarded by the civil organizations themselves. Fanny.
So first, my reaction is from national level perspective and then from the EU. On a national level, I don't think it's a smart idea, because if the authority or the decision is that bad, then I don't know how much it adds to your work to point out that dysfunctionality. But if it's not that bad, then I would not risk the relationship with this specific action. I would rather choose an option to work with them and make sure that they improve. On the EU level, that would never happen, because as I said, luckily, even with some flaws, I think the Article 29 Working Party and the EDPS are very much our allies. So I would not consider that.
Okay, now let me turn to the other two participants. In case, if you were nominated for a Big Brother award, I know it not because you deserved it, it's just a theoretical question, but in case, if there were some civil organization who nominated you and awarded this award to you, would you attend the ceremony? Would you receive this very negative award, or you simply disagree with it, and how would you behave?
I would advise everybody who receives such an award to attend such a meeting to react. Of course I would, but the main question is it really a smart action to issue such such a negative award to a DPA? I would say not really. There was also a similar situation in Austria.
Yes, I heard about
my former colleague, Austrian colleague, also received a Big Brother award. My impression was criticism is a good thing, especially if DPAs are completely different opinion than NGOs, and NGOs and individuals have any right to challenge these decisions like Max Schrems did, and they should criticize, but a negative award is the message: we are not allies, we are enemies. And I would say this is really silly. On the political message is not very smart. They have the right, but you will not anymore find open doors there. And
yes.
This, therefore, I would say, be careful if you consider to issue such an award to.
It's better to go to court.
Yeah.
Okay, these were very extreme cases, but this is exactly why I raised this question, to provoke some extreme opinions. Would you like to add something, Willem?
Yes, I would like to do that, because in Belgium also, the French and the Dutch speaking, because it's a complicated country here, we have two leagues of human rights, but they work together, especially for giving the Big Brother awards. And they started it 7 or 8 years ago, and they asked the Belgium Data Protection Authority and me in person to be member of the panel who choose the Big Brother
So
award.
you were on the safe side.
So but we discussed it in the Data Protection Authority, and we have refused to do that. And we have refused to do that because we thought, okay, NGOs and data protection authorities have to be independent, and we have not to interfere in these discussions. And secondly, we said, yeah, it's not impossible that at a certain moment there will be a nomination or even election of a big brother, of maybe the Data Protection Authority, of somebody, because we are 16 persons in the Belgium Data Protection Authority Commission, so it's a little bit complicated. And then we refused to do that.
Okay.
And I'm happy that we have taken this discussion. We're always going to the Big Brother Award. We are part of the discussion. And we only have had one, that the winner of the Big Brother Award was coming to attend the meeting, because it's always a whole day here in the KNS. It's in the great theater, the Flemish theater, they said, here in Brussels. There was only once that he came in. It was the head of the federal police who get this award, but who was not really convinced that he he awarded that, and he has given a whole explanation why he has taken this and this situation. It was an open debate. It was very interesting.
These are very interesting debates.
Because NGOs are not really rude people. They are civilized. They're taking a lot of points in account, but they have not, at the end of the evening, they have not retired. Take back the award. The
Okay,
award is
Charles
still with
feels
the
that
police.
I have a question for him, but before that, he would like to react on this. Yes. You.
I wanted to change the subject on this, but I mean, a more subtle technique is if DPAs had TripAdvisor accounts, and then you could vote, you know, wonderful down to terrible. But what I wanted to ask the panel, if I may, is looking at it from the standpoint, as I inevitably would as a political scientist and an analyst of public policy making, you can talk about DPAs and NGOs and the formal occasions in which they have things to do with each other, where there's a formal consultation and there's a reaction to a report and so on. Now, anybody who studies public policy and decision making knows that a lot goes on behind the scenes, in the sideshows, in the cafes, where you talk to each other. Even though you might shout at each other in the formal things, you need to rub along together in the informal occasions. And I was wondering whether, from the standpoint of the DPAs, have you found that those kinds of informal contacts have been important for you, not because the NGO is trying to put pressure on you to do something, but because you want to learn what the world is like out there from the perspective of what an NGO might be able to tell you about it. So compare the formal and the value of the formal and the informal contacts. Peter, what would you say?
Well, as I said before, it was very important for me to stay in contact with civil society and to discuss with them interesting or issues of common interest. Of course,
on an informal basis.
In an informal basis, yes. But nevertheless, as commissioner, I was independent, and sometimes I had to decide in another way. The NGOs wanted to push me. So at the end, you hear the arguments in a formal way or even in informal context, but at the end, you are responsible for your work, and you are bound to laws. And even if I am against data retention, if there is a data retention act in a country, you can criticize it in the public. You can provide a constitutional court with arguments, as I did several times, and all decisions in favor of privacy and data protection of the German Constitutional Court, I was heard. I had the chance to provide the court with our points of view, and we found these arguments in this in the ruling. So I would say yes, we need these contexts. Data protection authorities should have these contexts. There is no obligation, but for me it was really helpful to come to a view that not only is limited to the official statements.
Okay, so Fanny, please.
I'm a lobbyist, and that's not a bad thing. I lobby for EU laws and policies to respect human rights and for citizens' interest. And with the freedom of information background, because that's how I started this work, I really hated this position for a couple of months. It was just against my nature. But you can be sure that Google and Facebook and everybody else will have access to those people and to documents in a completely uncomparable way than NGOs do. So yes, you need to go behind those doors, but those doors have another side, and I wanted to mention the most formal, because you mentioned formal occasions, and the most formal occasion globally in the interaction of data protection authorities is probably the worst acronym in our field. It's the ICDPPC, which is the International Conference for Data Protection and Privacy Commissioners. So it just means that all privacy and data protection authorities and commissioners meet from around the world. And they have closed sessions and they have open sessions, and civil society has extremely limited opportunity to impact both the agenda and to be there as speakers. And the next edition of this event will be in Brussels, and we're working very hard, and we welcome the opportunity the European Data Protection Supervisor and the CNIL give us to do this better this time. It's gonna be in September or October this year. But it has been terrible, and all the companies are having private meetings there.
I would like to add something to these informal interactions. We also do them, and I see necessity exactly to do them. I mean, if we go and lobby our enemies, why shouldn't we go and talk to our allies behind the closed doors? Of course, but it's even more difficult, I think, for NGOs not to get co-opted in this relationship. DPA has still, in my opinion, the stronger position in this relationship. It is usually a much bigger body, much more influential body, public body. A small NGO like us talking to DPAs, we are, I think, we have to be even more careful, that's my point, in maintaining our integrity. So for us to hear that DPA has issue with, I don't know, effective redress procedures, and even hearing their argument and understanding should never lead to us not making those points in public, that there are delays or there are problems, and this is difficult. So in Poland, this is exactly the difficulty we are facing right now. We understand each other, we talk to one another, but at the same time in public, we sometimes have to not fight, but make points that are not exactly comfortable for the other side.
I'm afraid Charles cannot escape my question to him personally, not as a chair of the session. You have a broader perspective in this field as a political scientist and an experienced researcher. In your opinion, does political orientation or ideological orientation matter in the relationship between the two sectors? For example, a conservative DPA, I'm not talking about party membership or affiliation because it's out of the picture, and the liberal NGO, or the other way around. How do you see it? Does it matter?
I don't know that it does. Peter says it shouldn't normatively. I don't particularly think it matters. What I do think is probably more important than that is the misunderstanding by one side of what the other side is trying to do and the conditions under which they do it. For example, the misunderstanding maybe by DPAs that NGOs do, Kasi was talking about, you have a following, you have to, in public, make sure that you're following the people who subscribe to your organization, don't think that you are letting them down and that you are not fighting for them, so that inhibits what you might do. And on the other hand, I think NGOs very often don't understand the circumstances in which DPAs have to work, even to the extent of DPAs not having the statutory power to do the kinds of things that the NGO would like them to do, like issuing fines, like doing inspections, and so on. I think this has been the case, if I may say so, in the UK, where there has been, my perception is that there has very often been a misunderstanding of the extent to which the DPA can go, given their resources, given their legal scope, and so forth. But that's just my opinion on that. I think it would be important now to go to the
Yes,
audience.
we turn to the audience. Who has some comments or questions? First, you. Can we? Oh, we have all the mics. It's a safeguard to prevent interventions from the floor.
Thank you.
And Anna, second.
I have a question to both parties on the panel. First, I want to thank Willem, because it's the first time on the CPDP I hear the important word trade unions. I'm a trade unionist from Austria, so I like to be mentioned as a party in this whole game. And you said it's a kind of NGO. I think it's a little bit more than an NGO, because it's a democratically legitimated institution, a trade union. It's something voted by the workers. It's not something done because of we have fun to do it, but it's also we have also fun to do it, but it's also something workers have to have. So it's a legal background as well. And my question now is, as I see this quite weak in practice, how is the relationship from NGOs to trade unions, works council, shop steward, however it's structured in each nation, in each member state? How do they cooperate, or is it don't they? And as well with the authorities, how you mentioned that there is a cooperation with trade unions from the authorities side. But yeah, at least in Austria, I don't see this is too strong.
Okay, thank you. Can I have a short comment to this? Kasia already mentioned the existence of fake NGOs and things like that. We all know that we are concentrating on NGOs and DPAs, but of course, an important player in the whole game is the trade union. But we are full of, I wouldn't call them fake NGOs. There are the funny acronyms, Quangos, you know, quasi-autonomous NGOs, Gongos, government-operated NGOs, even Mangos, that's mafia-operated NGOs. So formally they are NGOs, but we are talking about the real, the civil society, those NGOs who are fighting for certain fundamental rights. Would you like to react to this?
Yeah, well, to fake NGOs, only one word. There are such NGOs, and some of them use the word data protection or Datenschutz, and they are fully financed by advertising industries or so. That happens, and you must be aware that not that the content of an organization is really the same, which is put outside or enshrined in the name. So you have to be critical if you have contacts to NGOs. Perhaps some organizations which do not care about data protection might try to have a look like data protection organizations. To the trade unions, of course. Trade unions are important players. I had some conversations with the chairman of the German trade unions on employees' data protection. That was a field of common interest. That is, so the question was, what are the requirements, the legal requirements in the field of employees' data protection? And until now, the results were a little bit negative. But the second is the Works Council question. Well, the Works Councils in Germany have a co-decision power, and therefore they are involved in the introduction of new technologies which might be related to surveillance of the workers, and there is also an exchange of views between the works councils in specific cases and DPAs.
Okay, let's have some more
AI.
questions. But you can
Just an advice. AI, I think, will open a lot of doors to work together between privacy NGOs and DPAs and trade unions.
Okay, Anna, please.
Hello, I'm Anna Fielder. I have a question which is related to a very important issue that Willem mentioned, if I can call you this, because I can't pronounce the surname. You mentioned Article 80.2 of the regulation. And to my knowledge, I mean, we've been lobbying for it in the UK as well. To my knowledge, virtually no member state has implemented it for various reasons. I know in Germany the VZBV has a power of injunction under the Injunction Directive, but not under this. But we've also been campaigning as NGOs to have comprehensive collective redress on the European level, and in Belgium I know you have it. So my question to you, because we've also seen some tensions between DPAs and NGOs on this issue, because obviously it's the job of the DPAs to take action, and why these upstart NGOs are interfering in this. But I just wanted to have a feel of what your opinion is on whether this article should be implemented across the European...
Please don't respond now. Let's have the two last questions, very brief questions, and please respond to all of them. First you, and then the last one. Brief questions, please, to the point, and unfortunately we need to give brief answers before the coffee break. Or
Thank you.
yes.
My name is Autumn. I'm a PhD candidate at Hebrew University, and fairness has to also add the fact that I used to clerk for a DPA in Israel, and also I used to be part of Creative Commons, which is an NGO, deals with copyrights, but still as a civil society member, I need to say that. So it sounds for me from the discussion that there are 4 roles for NGOs. The first one, and you can also think of them as strengths. The first one is litigation, is where actually you fight for rights. The second one was listed here is advocacy. Some call it lobbying, but that was the same word in other terms. The third one was raising issues to the public agenda. First of all, to the public, to the regulators, to the policymakers sometimes. And the fourth was educating the public, which is nothing to do with actually advocating. So that, for me, sounds the issue, and that if you can relate to that. And the second thing is that in my research, I looked at how how data privacy was regulated in Facebook due to the interaction with NGOs and the FTC as a privacy regulators. And I thought there was a very interesting interaction just because of the fact that the NGOs started working, and I wondered.
Okay, the last question, and I'm afraid we won't have time to respond to the questions now, but at least it's important to voice your question publicly.
I have a brief question. The term stakeholders is a large term. Is not the method used by the official organization to not necessarily have to deal with NGOs?
Your last words in 30 minutes? No? 30 minutes? Wishful thinking, 30 seconds. So if some of you would like to respond, maybe Willem, because the first question was directed to you.
I'm very happy with the question of Anna, and I think every country, and I hope Belgium too, will accept the possibility of Article 80.2. Because if you don't do that as a country, you are weakening the possibilities to defend data protection before data protection authorities, before the courts. So if you are taking data protection seriously, you have to implement 80.2.
Charles, for your concluding remarks, which should be very brief.
I think I agree with Willem on that particular point. My closing remark is, before I thank everybody, is to give a plug to a very good book written by my colleague Colin Bennett called The Privacy Advocates. If you haven't read it, I think it would be worthwhile to do so. He wrote this a number of years ago. It remains for me to thank the panel for their very interesting and perceptive comments. Thank, of course, Ivan for his wonderful moderation. To thank the audience for voting in unpredictable ways. So we haven't been with Cambridge Analytics, nothing to do with them. So thank you all very much, and thanks for